Hello, everyone. My name is Danielle Morris, and I'm a partner in the International Arbitration Group at WilmerHale in Washington, D.C. I'm grateful to ASIL and the organizers of this panel for the invitation to moderate what is sure to be a lively and topical discussion on investor-state dispute settlement, or ISDS, and climate change. I'd also like to thank Intercentra Publishing Group, the session sponsor. Before we get started, a bit of housekeeping. You are welcome to submit questions over the course of the panel using the Q&A button at the bottom of your screen. We plan to leave time at the end of the discussion to address as many of these as we can. I'm conscious of the fact that we only have an hour, so I'm going to move straight to introducing the panelists and their topics, and I'll let them take it from there. Our first speaker is Kevin Moore. Kevin is a partner in the trial and global disputes practice at King & Spalding. He specializes in cross-border disputes and has represented clients in more than 20 arbitration matters under a variety of institutional and ad hoc arbitration rules. He also frequently represents clients in court proceedings related to international arbitration, as well as in business disputes that span multiple countries. Kevin will provide a brief overview of the issue and then address the claimant's perspective on what an investor expects from ISDS with respect to investment protection in the context of both green energy and fossil fuel investors. Next, we have Gabriela Alvarez Avila. Gabriela is a partner in the international arbitration practice of Curtis and acts as counsel for foreign states in investor-state arbitrations conducted under the arbitration rules of ICSID and UNCITRAL. She has also acted as counsel and arbitrator in commercial arbitrations. Gabriela has been designated by Mexico to the ICSID panel of arbitrators. Gabriela will give us some highlights of how tribunals have decided these issues, with a focus on fair and equitable treatment. Our third speaker is Carlos Solé. Carlos is partner head of energy consulting and economics and regulation at KPMG Spain. He is an industrial engineer from Comillas University and has a degree in general management from IESE Business School. Carlos joined KPMG in 2010 after having served for 15 years at the Spanish National Energy Commission as Director for Electricity, where he was directly involved in the liberalization process of the energy sector in Spain. More recently, he has been acting as a regulatory expert in several cases in the context of arbitration proceedings under the Energy Charter Treaty between renewable investors and Spain. Carlos will address the state and regulatory perspective with a focus on Spain. Last but not least, we have Dr. Kasturi Das. Kasturi is an economist and a trade and climate policy expert with more than 2 decades of professional experience conducting research, advising, advocacy, and teaching. At present, Kasturi is a professor of economics at the Institute of Management Technology, Ghaziabad, Delhi, NRC, India. A British Chevening Fellow at the University of Oxford, Kasturi advises the Government of India on trade and environment. She is also a member of Climate Strategies London and of the World Economic Forum's expert group on trade and climate change. Kasturi will discuss the latest trends in renewable energy regulation, the need for regulatory support, and potential considerations also from a trade perspective. As you can see, we have a truly impressive panel with experience in all aspects of this topic. Without further ado, I will pass the mic to Kevin to get us started.
Thank you, Danielle, and thank you to ASIL for putting together this panel. The title of our panel asks whether ISDS is a barrier, a facilitator, or neither regarding the global fight against climate change. And I will commit to answering that question, at least insofar as lawyers answer questions. But first, I'll take a minute to briefly frame the issue and set the stage for discussion. So obviously, we're talking about this because there is a growing consensus that the world economy needs to transition away from fossil fuels and toward alternative energy sources and renewable energy sources in order to avoid worst-case climate scenarios. And broadly speaking, state policymakers have 2 sets of tools at their disposal in order to make that happen. One set of tools, which we can think of as the carrots, are tools designed to encourage investment in renewable energy sources. Another large set of tools are tools designed to discourage investment and hasten divestment in hydrocarbon production, which we can think of as the sticks. And one way to frame the question is whether the ISDS system, which is designed as it is to protect and promote investment in a more or less policy neutral way, acts more as a facilitator of the carrot side policies, more of a barrier to stick side policies, or neither, or a little bit of both. And another way to frame the question is whether there is an unavoidable tension here, or whether or not there's some way that that tension can be reconciled. So I will provide my answer to the question, which comes from the perspective of my practice. I represent investors in renewable energy in ISDS disputes arising from changes to regulatory regimes that affect their investments after their investments have been made. And so my focus will be on the carrot side of things. And the view of my clients is that ISDS is, in fact, a very, very important facilitator of renewable energy investments, that it is, in fact, indispensable. So, at the risk of stating the obvious, the carrots exist because renewable power plants cannot compete with conventional power plants in a deregulated market without state backed incentive policies. The most obvious of those incentives are subsidies in various forms that are designed to reduce the gap between the cost of renewable energy production and the cost of conventional energy production. But it also involves other policies that are designed to reduce the overall cost of renewable energy production, such as grid priority and exempting renewable producers from grid balancing costs, things of that nature. And the issue is for investors in this sector is that because of the economics of this sector, widespread investment will only occur if investors perceive that these incentive policies will remain stable for a long duration. These projects are hugely capital intensive. Investors typically have to spend 85% or more of the total lifetime cost of production upfront to build the asset. And like all sunk assets, they are extremely vulnerable to regulatory action after plants are built. But renewable plants may be even more vulnerable to regulatory action than sunk assets in other sectors are, for a couple of reasons. First, the ratio of the upfront capital cost to the ongoing operating cost is even higher in the context of renewable plants than it is for many other kinds of sunk assets, which means that there's more room for regulators to cut remuneration after the investments are built before they get to the point of cutting so deep that it makes sense for investors to just shut down. Second, because technology costs in this sector are constantly falling, there's a certain kind of buyer's remorse that sets in. It's, the policymakers and consumers sort of wonder, why are we paying 40 cents per kilowatt hour for power from this plant that was built 5 years ago when we can get power from the same kind of plant that's built this year for a fraction of that. And so in this context, ISDS is absolutely a facilitator of renewable energy investment because investors need to perceive a very high degree of stability in the regulatory framework for a long time. And ISDS puts teeth in the commitments that states make to maintain their incentive frameworks for a long time. And in the long run, that kind of regulatory stability that ISDS is designed to promote facilitates renewable investment by reducing regulatory risk and thus ultimately reducing the cost. The problem is that renewable power is not politically very popular, or at least, to be more precise, paying for these policies is not very popular. So when there is a recession or a change in administration, there is enormous pressure on governments to retrade the deal for renewable investments that have already been made. And there is enormous pressure on domestic courts to let governments do that. And that, I would suggest, lies at the very core of what ISDS exists to address. And therefore, in my view, and this is a view that I advance on behalf of my investor clients, but conveniently, it's also a view that I hold personally and as a student of the law and as a citizen, ISDS production should be at its zenith when a state promises specific incentives for a defined duration in order to induce investment and then retrades the deal after the investment is made. To put that slightly differently, in the carrot context, deference to regulatory discretion should be at its lowest, and scrutiny of regulatory action should be at its highest or most strict. Unfortunately, in my view, in the view of investors in this sector, that is not exactly how the jurisprudence has unfolded in renewable cases that have been decided in the past few years. Investors, I think, have prevailed in most cases, but generally only partially, and investors have lost some cases that from the perspective of the investment community, they should have won. I think that there are the outcomes in individual cases, I think, are beyond the scope of my remarks, but I would make observations about two trends that I have seen. One, and this is perhaps a somewhat technical issue, is that some of the jurisprudence has placed too much weight on whether states have made specific commitments to particular investors, as opposed to providing incentives through a general regulatory framework, rather than in contracts, for example. And I think one reason why some tribunals have focused so much on this issue is that ISDS jurisprudence really has grown up, if you will, in the context of large infrastructure projects that cost billions of dollars and are heavily negotiated with the host government. But the regulatory context in the renewable sector is very different. Renewable plants typically are smaller, they're more diffuse. We're not talking about a handful of enormous power plants. We're talking about many thousands of small power plants. And the same regulatory framework applies to a 7 kilowatt plant that I put on the roof of my house as applies to a 10 megawatt plant or a larger plant built by developers. And governments do not negotiate individual deals in this sector. They enact regulatory frameworks that make a broad offer to the market that if you do A, build the plant, we will do B. We'll provide a certain set of incentive policies that make that investment attractive. So the question really should focus more on substance rather than form. And some of the case law, in my view, has been a little too rigid regarding formalistic requirements without appreciating these differences in the regulatory context. The second theme, and this really goes to the heart of the question and the title of this panel, is that some of the recent awards in this space seem insufficiently rigorous in evaluating states' arguments regarding their right to regulate. No one disputes that sovereigns have broad regulatory authority, but that authority includes the power to make binding commitments about how the state will regulate in the future in order to induce investment. And even in cases where tribunals have found that investors did have legitimate expectations to stability, many tribunals have afforded a considerable degree of discretion to government action that derogates those expectations under various labels of margin of appreciation or the right to regulate. And that, in my view, and the view of investors in this sector, is inconsistent with the strict level of scrutiny that should apply in the carrot context. So strict scrutiny does not necessarily mean that no regulatory action is ever justifiable. There may be extraordinary circumstances where an emergency or vastly changed circumstances might justify regulatory action. But in the carrot context, strict scrutiny should require a very rigorous evaluation of factors such as, did the state cause the change in circumstances? Was the change foreseeable? Did the original regulatory framework allocate that risk? Did the state exhaust all reasonable alternatives? And is it possible to compensate once the emergency has passed? Some of the case law in this sector has applied a much less precise and rigorous standard that asks whether a particular change was reasonable, which in my view should be the floor level of protection required of states when they have not made specific commitments that create legitimate expectations. And more should be required when they have made such commitments. I will just very briefly conclude by touching on how that vision of ISDS might relate to the stick side of things. And really, my answer to that is I don't have much to say about it because I don't think we have a very good idea yet of what the stick side policies really look like. And measures that discourage new investment will look very different from measures that aim to curtail existing investments. Measures that aim to reduce demand for fossil fuels will look very different from measures that aim to curtail production from existing investments. But I would finally just conclude by saying that I suggest that a conception of ISDS that applies its highest level of scrutiny to the carrot situations leaves considerable room for greater deference to the stick side policies, at least when they do not implicate explicit commitments that had been made to investments in the fossil fuel sector. So that I'll conclude my remarks and pass it back to you, Danielle. Thank you.
Thank you very much, Kevin. And with that, I will pass it on to Gabriela.
Thank you, Danielle. Good morning, everyone. I'm very honored to participate in this year's annual meeting of the American Society of International Law and sharing this panel with my distinguished colleagues. I'm also really grateful to the organizers for this invitation, and to Danielle and Ryan for their splendid organization of this panel. The purpose of my participation is to provide an overview of how different tribunals have interpreted treaty protections in the field of clean energy. In particular, I will look at how the FET standard has been applied in the framework of renewable energy disputes against Spain. Since the purpose of our discussion is to assess whether ISDS would help mitigate climate change, and we all know that regulatory actions from states are required to achieve that goal, I thought it would be interesting to analyze whether decisions of tribunals in this field would provide certainty to both states and investors when deciding the scope of treaty protections with regard to the exercise of the regulatory power of the state. I have looked at around 16 awards rendered in cases brought under the ECT against Spain, and was able to identify 5 different manners in which the scope of the same provision, that is Article 10.1 of the ECT, has been interpreted. I'm leaving aside the particularities of each case, since my purpose in reviewing these awards was to identify the outcome determinative approach taken by those tribunals. The first trend that I identified in applying the FET standard starts with the ACER award, which then was followed by other tribunals like in the Soles, Greentech, and Nova Energia cases. In this first trend of awards, tribunals acknowledge Spain's right to regulate and make changes to the regulatory regime, but found that the FET standard protected investors from radical changes to the regulatory regime in ways that deprive investors who invested in reliance on that regime of their investment's value. Thus, under this interpretation, Article 10.1 of the ECT provides fundamental stability and incorporates an economic approach, since the notion of deprivation of value is included by those tribunals as part of the FET standard. And let me note here that generally speaking, the deprivation of value element is found in the expropriation standard rather than in the FET standard. There is a second type of interpretation that can be found, for example, in the Masdar or Nestera cases. This second interpretation, or the second trend, underlines that the state's right to regulate cannot be exercised in an unreasonable manner in violation of specific commitments taken vis-a-vis the investor. And this is one of the trends that actually Kevin identified. In these cases, tribunals found specific commitments were entered into by Spain in the form, for example, of letters addressed to the investors. And those specific commitments were violated by Spain when the regulation was changed. A third interpretation of the same provision is that the FET standard protects legitimate expectations that arise from the applicable legislation. These tribunals, and there are a number of these tribunals that consider that Spain provided specific commitments to investors in the applicable legislation, and in particular, that one provision in the legislation granted stability, which was breached when the legislation was changed. This approach is obviously different from the previous one, inasmuch as in this third approach, there is no need for specific commitments addressed to the particular investors. But general provisions in the legislation are enough to find specific commitments from the state. A fourth way to apply the FET standard of Article 10.1 of the ECT is based on looking at the fundamental characteristics of the regulatory regime put in place by Spain. Under this interpretation, the FET standard protects against changes to those fundamental characteristics, which these tribunals found included a reasonable rate of return for the investors. So on this basis, tribunals concluded that a breach of the FET standard could only be assessed by looking at the specific laws for each plant. And thus, here, every tribunal needed to make a damages analysis to be able to evaluate whether a breach of the FET standard had occurred. And some of the cases that followed this trend were the REF infrastructure case versus Spain or the PV investors case. Finally, recently, in a case brought by German companies against Spain, the tribunal found that as long as the changes in the regulatory regime are legitimate, reasonable, and proportionate, no FET breach can be found, as opposed to the other cases. In this case, the claims were rejected in their entirety because this tribunal found that the regulatory change made by Spain, the same regulatory change that was applied in the other cases, was legitimate, reasonable, and proportionate. From the above, it would seem that the FET standard included in the ECT has very different scopes. It could allow changes to the regulatory regime as long as there is a legitimate purpose. It would forbid those same changes that would violate the stability guarantees in the legislation. It would forbid radical changes if they have an economic impact, and would go as far as measuring the FET standard against a specific rate of return. These various interpretations of the scope of this treaty provision would, in my view, make very difficult for a state to exercise its regulatory power to mitigate climate change, because it shows a lot of uncertainty as to the scope of the state's obligations under the ECT. There are, however, still a number of pending cases against Spain that will be decided in the near future. And it would be interesting to see whether those tribunals provide more certainty regarding the scope of the FET provision of the ECT. It also remains to be seen what will be the outcome of the around 11 pending annulment proceedings initiated by Spain, considering that the ACER Annulment Committee, which is the first to have decided on an application, has very recently annulled the ACER award in its entirety. Thank you, Daniel. I give you the floor back.
Thank you very much, Gabriela. Carlos?
Yes, thank you very much, Daniel, and thanks to the organizers for their kind invitation to participate in this meeting. Well, my initial contribution will be in a certain way, a continuous reflection of what Gabriela has been saying, because we'll be focused on sharing with you some reflections on how the European experience, and particularly in the case of Spain, we have been developing the regulatory framework for renewable energy, and which has been the changes and the amendment introduced by regulators that have struck new and existing investment that were deployed under a former regulatory model. As you know, by the end of last century, the European and also the Spanish energy policy was driven towards increasing the installed capacity for renewables. The principal reason for this national approach was the mandate included in the Electricity Power Act in 1997 and the European Directive of 2001, whereby 12% of gross domestic energy consumption was to be supplied using renewables by 2010. The commitment to RES to renewables was supported by their contribution to security of supply and energy access, their contribution to economic and social development, and their benefits in terms of environmental protection. Such ambitious targets in terms of deployment of these technologies called for a long-term strategy, which was set forth in the National Renewable Energy Action Plan prepared by the government for that purpose, aiming at three main targets. First, defining the specific growth objectives by technologies. Second, identifying potential barriers to such growth, specifically in terms of regulatory, economic, and administrative barriers. And third, proposing measures to overcome such barriers and secure the achievement of the target. The specific regulations set forth by the economic incentives regime around a feed-in scheme, which essentially provided renewable producers with a long-term regulated fixed payment per unit of electric energy fed into the grid. As you know, in the electricity market, the sale price for producers absent incentives is the wholesale market price, and it is intended to reflect the cost of producing electricity. However, electricity prices do not include certain costs associated with the negative impact of conventional generation technologies, for instance, waste management, emissions of pollutants, or exposure to foreign fossil fuel resources. Put another way, electricity prices do not fully remunerate the positive impact of the generation of electricity using non-pollutant, waste-free, or domestic renewables. These circumstances place renewables at a competitive disadvantage against conventional technology. And under these market conditions, specific public policies and therefore require in order to increase the deployment of renewables capacity by providing stability and predictability in order to create an environment of confidence that can attract the necessary investment to meet the energy policy targets. In particular, the Spanish government essentially promoted renewables deployment through this feed-in scheme that was in force in Spain from the 1980s until its repeal in July 2013. The government's decision to implement the feed-in scheme was justified on the basis and considering the multiple benefits that this system could provide for the renewable deployment. This regulatory scheme has proven to be highly effective for attracting investment in renewables due to the high degree of predictability and long-term stability in the revenue streams. Indeed, 75% of the PV capacity installed worldwide by 2010 was attributable to feed-in schemes. Thus, the feature of feed-in schemes are best suited to attract investment in renewables by large volumes, maturity of these technologies, and as has been mentioned before, high ratios of upfront investment cost to operating cost. Under this regulation, the feed-in scheme set in place by the Spanish government included incentives that were set for each specific technology on the basis of different operational and financial assumed benchmark values for the relevant variables that defines renewable projects. As in the design of the remuneration scheme for any regulated activity, three basic variables common to any economic activity were taken into account. First, income, second, cost, and third, rate of returns. It should therefore be noted that in a feed-in regulation, the benchmark values for economic variables and the benchmark rate of return were merely the auxiliary input data used with the sole purpose of calculating the only relevant output of the methodology. In other words, the specific fixed payment or the value of the feed-in tariff in euros per megawatt hour per unit of. And then the Spanish government launched a series of reforms that undermined the economic regulatory framework for renewable facilities until it was removed altogether in July 2015. The rationale behind all these changes was to reduce the so-called tariff deficit. The tariff deficit is a financial imbalance in the electricity system that arises when the money collected from the agents through the access tariff is below the required levels. And when the regulated revenues collected in the system are lower than the regulated costs incurred, an annual imbalance is created. And when such imbalance exists year after year, a structural imbalance is created in the economics of the electricity system. The Spanish government introduced new regulatory measures, creating a new scheme, in my opinion, for the remuneration of renewable facilities applicable to both the new and existing investment. And this is quite relevant. This is not only for the future investors, but also for the existing investors. In a nutshell, it means that instead of a feed-in tariff per unit of energy fed into the grid, under the new scheme, each real facility would achieve a reviewable every 6 years target rate of return based on the parameters of the standard facility with which it has been associated, the specific facility. This feature, in my opinion, constitutes a paradigm shift with respect to the previous feed-in scheme, and whereby incentives were fixed and defined ex ante for the entire period over which they were granted facilities. It is absolutely clear that the Spanish electricity sector was subject to economic and financial imbalance that called for a structural reform. However, it was not possible to anticipate that the regulatory framework was going to be transformed in such a way. In my opinion, the measures that were adopted are not reasonable because they are not compliant with the basic criteria of a good regulatory practice recommended by international institutions, including the European Commission, the International Renewable Energy Agency, IRENA, or the World Bank, among others, with regards to the criteria of stability, predictability, efficiency, effectiveness, proportionality, objectivity, and transparency. Players that invested because they were attracted by the incentives set by the government and designed to fulfill certain long-term energy policies and environmental objectives saw their incentives amended only after their investment decision was made. The negatively affects investors' perception on the regulatory risk and therefore the potential for attracting new investment. My main concern on the regulatory framework evolution and the adopted measures with clear implication on the existing facility refers to the structural change that has been passed without any transitory period or compensation. I do not put in question the need to address the problem, the tariff deficit, that finally has been tackled by the government. My criticism is there focused on the lack of regulatory orthodoxy of the measures and not in the effectiveness. I will finish with an additional reflection on the validity of the disputed measures. According to the principle of proportionality, the measures adopted must be considered the best instrument to achieve the objective. And my question is were there available alternative options which would have enabled the government to solve the tariff deficit issue, but adopting less restrictive and distorting measures? And here my response is yes. In my opinion, there were a range of alternative measures to those adopted, which would have had an equal or greater impact on combating the tariff deficit and security, the financial stability of the electricity system, while maintaining a commitment to regulatory best practice. And this is what I would like to transfer during these first comments and reactions. So many thanks for your attention.
Thank you very much, Carlos. Kasturi.
Can you hear me, Daniel? Hello?
Yes, we can hear you.
Okay, thank you. First of all, thanks to ASIL for inviting me in this very interesting discussion. Thank you very much, Daniel, and all my fellow panelists, Ben as well as Brian, for having me here. Very enriching discussion, I would say, has been going on, and I would also put my penny on the table. So the point we are trying to discuss here is whether ISDS is a facilitator or is a barrier or neither. So my question here is whether we can look at ISDS as a facilitator of renewable energy investments. If you look at the discussion, the way it has happened, and the discussion about ISDS, you would know that environmentalists have been quite critical of investor-state dispute settlement, ISDS, because according to them, it does not allow enough regulatory space. And some of our previous speakers already talked about the issue of importance of getting regulatory space. However, in more recent past, in tandem with the rise in renewable energy disputes, it is often discussed that you actually might benefit from having an ISDS provision in the investment agreements, because that would help you to attract a huge end that might be required for transition to a green energy pathway. So what I plan to do is first to share with you some data analysis of mine. What I have done here is that we can see there are 1,023 ISDS cases which are on the UNCTAD portal till 31st December 2019. So this whole set of cases reveals some interesting statistics. First is 1,023 cases. The total number of energy cases would be 310, that is around 30%. Out of this total 310 energy-related cases, as many as 164 are clear-cut fossil fuel cases, 93 are clear-cut renewable cases, 5 are nuclear, and there are yet another 48 cases for which it's not yet clear from the database provided on the UNCTAD portal whether these cases are fossil fuel or renewable. And these are mostly electricity-related cases, distribution, transmission, etc. Now, if we dig deeper into this data, then we can see that although there is a continuous flow of renewable-related ISDS cases since 2010 onwards, it doesn't mean at all that the fossil fuel-related cases have come down. In fact, in the contrary, you can say that the skewness in the distribution of fossil fuel cases has been significantly lower than that you can see in case of renewables. On the other hand, for renewable-related ISDS cases, we can observe a significant spike in cases during the period 2013 to 2016, but it has come down after that. And in 2019, if you look at it, there are 6 renewable cases compared to 14 fossil fuel cases. The question then is, why do you see the spike during the period 2013 to 2016? And this is mainly attributable to the huge number of cases we can see in Spain. And we have already heard our previous speakers discussing about the Spanish experience at length. So after Spain, which I can say 46 cases are there, we have Italy, which has got 10 cases, and other countries do not have as many cases. The short point I'm trying to decipher from this data is that the proliferation of renewable energy-related cases is not kind of a global phenomenon, so to say, nor is it the case that the fossil fuel-related ISDS cases have become less frequent generally and renewable cases have become more frequent. That's not the case. The second point I'm trying to flag here is there anything about renewable energy related investment that makes them particularly susceptible to incentivization through ISDS? Now, to my mind, if you are looking at this issue from a decade back perspective, then one could argue that the political and regulatory risk was a big concern. And there are studies, particularly say, I would refer one study done by the Economist Intelligence Unit, which found that these are some of the real concerns. However, currently, if you look at the scenario and over the past 1 decade, you can see that producing electricity from wind and solar PV is much more cost effective at this point than generating it from new coal-fired power plants. Although we still have a lot of teething problems, however, according to the Standard & Poor global ratings, you can expect the asset class of renewables to grow in capacity and with improving efficiencies and cost competitiveness going forward. Now, in tandem with the reduced need for policy incentives to sustain renewable energy that we can expect to happen going forward increasingly, the importance of ISDS cases might actually go down gradually. This is not to say that the renewable energy investments would not need regulatory stability and predictability, and I agree with my previous speaker on that you really need stability and predictability. However, as of now, we do not have enough evidence to suggest that at this point, ISDS is the only way to go about it. The third point I would briefly touch upon is ISDS essential to attract renewable related FDI? Again, there are many studies and econometric studies being done. However, we do not find any conclusive evidence to suggest that ISDS is essentially required for you to attract renewable related foreign direct investment. Coming from India, I would also share a very interesting piece of information with you. India was having in its bilateral investment treaties, traditionally, which it entered into during early 90s, I would say, it had a very strong ISDS provision in those bids. However, in 2016, India came up with a new model bid in which India diluted the ISDS provision and made it very, very difficult to actually make use of. Now, it does have an ISDS provision, but it is very difficult to make use. That's the point. Also, in 2017, we can see that India scrapped as many as 50 bids. So these are quite serious policy steps being undertaken by the government of India. However, if you look at the trend in renewable energy investment, you will see that over the past 5 years or so, it is showing an upward trend. And despite the policy changes being made in 2016 and 17 regarding ISDS, we can't see the investment and FDI coming into India regarding renewable energy. It's not going down. So though it's not an econometric study, I thought it would be an interesting trend to share with. The fourth point is, as I was already telling you, that there is still a case for regulatory predictability for the investors to make investment in renewable. However, we do not have enough evidence to say that ISDS is the only way to go about it. On the contrary, ISDS may actually give far more protection to fossil fuel investment. Mind you that fossil fuel subsidies are far more higher than renewable energy related subsidies globally. So perhaps if we look at the issue of regulatory chill, one could argue that regulatory chill could be more in the context of fossil fuel investment compared to renewable investment. What is important to my mind is that regulations should be flexible enough, and there will be scope for calibration over time with changing market and technology scenario. Perhaps there are many things we could learn from the Spanish experience as well as the existing regulatory experience in the sphere of ISDS while developing our regulatory framework for attracting renewable investment. The final point I would like to make here is that you should be aware that the regulatory chill may not only be related to ISDS or investment-related agreement, but it could also come from the trade framework. For instance, the World Trade Organization, the multilateral trade body that deals with the regulatory framework for international trade. And my previous speakers were talking about at length about feed-in tariff, and they have discussed that how and why feed-in tariff is a kind of policy intervention which is particularly relevant and essential for renewable energy. Now, feed-in tariff and local content requirement are some of the policy measures which are globally extensively used for renewable energy support. However, none of these are compatible with WTO agreements. So if you look at the trend of WTO disputes since 2010 or so, you will find that there have been as many as 14 WTO disputes on this space of renewable and clean energy. And among them, 50%, like 7 cases, relate to either feed-in tariff or local content requirement or both. So this is not unexpected given the extent to which feed-in tariff and LCR are being used in the renewable energy support schemes. Now, my point here is that if you need regulatory certainty and room for cleaner and greener energy future, then there is a case not only for looking at the regulatory framework under investment agreements, but also there should be coherence among different regimes under climate change, trade, as well as investment. I stop at that, and over to you, Daniel.
Thank you very much, Kasturi, and all of our panelists. We have some questions from the audience that I am happy to relay. So I think the first question I will direct to Gabriela, at least in the first instance. Others are welcome to join in afterwards if they have views. So you had pointed to the importance of consistency and interpretation of the FET provision, I think for the benefit of states, but also for the benefit of investors. And so one of the audience members asks, given the issues raised in ISDS cases involving climate change, what criteria should arbitrators meet, such as familiarity with climate change science and law? So I would be curious to know from you whether you think there are particular characteristics of arbitrators that are important in these kinds of cases, and if so, whether a particular background or expertise may help to contribute to a more consistent view on the international validity of these measures.
Well, in my view, it is very important that arbitrators understand how policy from states need to be made, because it was very interesting to me to listen on the one hand to Kevin saying, there's not enough scrutiny from tribunals, not enough because basically not enough compensation for the big investments made up front. And on the other hand, and at the same time, Carlos saying, well, there was a regulatory framework put in place with a long-term view, but it needed adjustment. There were problems and it needed adjustments. And those adjustments were not the ones that, in my view, were the ones that should have been made. And it reminded me a little bit of what happened when the Argentina crisis. Like, some of the criticisms were, well, those, the decisions taken by the states were not the right ones. And I think there are similar, in a way, situations. You have a crisis, different type of crisis, but a crisis. And the state has to make a policy decision in the benefit of everyone, not only of the investors that put some money up front, but the taxpayers. And so when I listen to the fact that I didn't receive enough money, and on the other hand, taxpayers saying, I pay too much taxes, that's the policy making decision that needs to be made. And in my view, tribunals need to be mindful, members of tribunals need to be mindful to those decisions. And characteristics of people knowing that these type of decisions are tough decisions that need to be balanced decisions. Considering, of course, that you want this clean energy, you want to give investors enough incentive to put upfront money, but that adjustments in the life of these policy decision-making processes need to be made. And so I leave it there. Maybe my colleagues want to add something.
Yes, I don't know if any of the other panelists wanted to add to that. Okay, I guess then, Kevin, bridging on from what Gabriela was just saying, we have a question asking whether the renewable arbitrations are consistent with the traditional model in which a state was deemed to have provided stabilization only if it had specified the applicable legal regime and the relevant contract or regulation and committed that any changes would not be applicable to the investor. So this reminds me of what you were talking about, specific commitments versus a legislative regime, and also picking up on what Gabriela was saying about the need for a regulatory regime to have some, and Carlos also, to have some scope for adjustment.
Yeah, thank you, Danielle. So I think the answer with respect to the Spanish regime is a little bit of both. So there were no contracts between investors and the government in the Spanish regime, which is a point that I touched on. The commitments were all contained in a regulatory framework. And so I think I explained earlier what my view that to the extent that the historical understanding of this law really looks at whether or not there is a contractual stabilization clause, that seems to me to be out of step with the regulatory paradigm that applies not only in Spain but in most countries to this sector in which there are not individualized contracts that are negotiated with investors. That then raises the question of whether there needs to be some kind of stabilization commitment in the regulatory framework. And in fact, in Spain, there was a regulatory provision that said that changes to the remuneration that are enacted in the future will not apply to existing plants. I'm obviously paraphrasing a great deal. So in that context, there was a kind of explicit stabilization commitment. But I would argue that that's belt and suspenders. That in a situation in which the regulatory framework is promising a defined remuneration for a defined period of time, that is in effect self-stabilizing, and that it's belt and suspenders to then require an additional provision that says, oh, and we will not change that. And so I'll leave it at that so we have time for additional questions.
Thank you very much. So Carlos, there's a question asking for clarification. So you had mentioned that in your view, Spain should have considered whether there were alternative measures that would have been less restrictive, but still would have accomplished Spain's policy goals. And the question is whether that is a view of what good regulatory policy is, or whether your view is that's a requirement by the ECT or both. So if you could please clarify that.
Okay. Well, yes, my comment on this was regarding the reflections that when you are adopting a structural change in the regulation, that I agree that the change is a dynamic way of work and need to be amended and adapted sometimes. But what is critical for the regulator is to analyze if the measures that are being adopted are the best one that can be taken to solve the problem that they have, that they are facing. And in this case, if you have to introduce structural changes for the existing facilities, you need to accommodate with transitory provisions, with compensation mechanisms to make a more smoother transition to this change. But this is the general principle that, in my opinion, in terms of good regulatory practice, should be maintained. But if you solve the problem, this is like a menu in a restaurant. You go there and you have the opportunity to choose different ways to solve the problem, different ways to select what you are going to eat in one moment. And this is the point that for me is quite relevant, to analyze if the environment that was created in this situation regarding the signals that the government and the regulator was sending to the investor, it was expected that such a structural change could be happening. And in this point, it's quite relevant to analyze if the regulator was sending additional options or alternatives to follow to solve the problem. And in this case, in my opinion, there were other ways to tackle the difficulties of the tariff deficit.
Excellent. Thank you very much. So we have just a few minutes remaining. So Kasturi, there was a question that picked up on one of my own reactions to what you were saying. I was very interested to hear your recent research that India moving to the new model bid and terminating its older bids doesn't appear to have had an impact on foreign investment in the renewable sector. And so the question from the audience is a question of whether the investments that have been made would be covered by old bids under sunset clauses, whether they're a continuation of investments that were made while these older bids were still in place, or whether these are in fact new investments that are covered only by the new model bid or new bids that are in place rather than the older bids with more access to investment arbitration.
Can you hear me?
Yes.
So that's a very interesting question, but I'm sorry that I'm still, this is a work in progress and I have not gone into the details of each and every investment, but I'm actually trying to look at this. And however, I can tell you that from my understanding, the new model bid is very restrictive and it doesn't have much scope for the investors to find, justice, I would say. Because there are many provisions, but due to paucity of time, one important provision is that at least for 5 years, the investors must try to find recourse in the domestic system, legal system. Now that's a bit too much. And if you look at, frankly speaking, the Indian judiciary, the way it functions, it doesn't move so fast. So that would be quite onerous for the investors, to be frank. So I think, to my mind, the new model bit is very restrictive, and there may be scope for more, justice for the investors. And we can also see that we do not have too many countries interested in a new model bid. But I am doing this research, and I have to really look into this question further.
Yes, it will certainly be fascinating to see empirically whether investment in this region is really dependent on bid protection or whether there are other factors that may be driving it as well.
Exactly. Right.
So let me see if we have time for one other question. So there's a question directed at Gabriela and Kevin that says, recent bids encourage sustainable development or try to protect regulation promoting it. How will these provisions interact with FET? So this seems to be a continuation on what we've been discussing. I think one potential spin on this, Kevin, you were distinguishing between analysis of carrots and analysis of sticks by tribunals. And perhaps you could elaborate that on that briefly here in our last minute and a half.
Yeah, so the point I was trying to elucidate is that I think that the jurisprudence ought to place a greater emphasis on whether a particular regulatory measure is in derogation of a previous commitment that had been made, in which case there should be very, very low deference and strict scrutiny, as opposed to a situation in which the regulation is a general regulation for the benefit of health, environment, and welfare, and does not derogate specific commitments that have previously been made to investors. And I think that framework allows a greater amount of discretion, of deference to discretion for the stick kinds of measures that to me, and this is obviously very broad, and the devil is always in the details, but to my thinking, that is consistent with broad policy aims that the ISDS system should be consistent with promoting sustainable development.
Thank you very much. So I see we are coming up on the end of our time. We are on a strict schedule here. So I would like to thank all of the panelists very much for these very interesting contributions, to thank ASIL and the organizers and InterCentra Publishing Group one more time. We hope you will all continue the conversation on these very timely issues and that you enjoy the rest of the programming over the next 2 days.
Thank you, Daniel. Thank you.
Thank you very much.
Thank you.